Okay, hi everybody. First off, I just want to make sure that everybody can hear me clearly. The volume is up, that everybody can see me. So I've got the Q&A open and the chat open as well. So I'll be watching that. Uh, so the topic for today is has to do with inherited IRAs. Uh, it's about what happens with your retirement accounts when you leave them to your kids or to other beneficiaries. And when we say IRAs, I'm not just limiting this to actual IRAs. This includes Roth IRA accounts. It includes 401ks. It can include certain types of annuity accounts. Generally, anything that there is some income tax owed that hasn't been paid yet by you. And the reason why that's different is when it comes to your kids or your beneficiaries, they're the ones who will have to figure out the taxes and pay the taxes on those. So that's why it matters what you do with it now can change the benefits and consequences for them. So these are kind of the four main topics we'll talk about today. Um, I'm going to try to, I've got about 17 slides. I'm going to try to cover them in about 2 or 3 minutes each. I'll pause to answer any questions after we get through every major section. The four topics really going to be about the mistake that most kids make when they inherit an IRA, why it can be worse for the kid to inherit an IRA than to get nothing at all in some cases. What exactly is a tax advantage legacy trust? And what does that trust do for your kids? So I wrote that as how it'll reduce your kid's tax bill. I'll also talk about how it'll actually help your kids grow the inheritance. So the first uh, issue to cover is what is an inherited IRA? How is it different from a regular inheritance? So the way to think about an inherited IRA for your kids is that it's kind of like the story about the goose that lays the golden egg. The idea is there's this money that sits there and they inherit it. Used to be it was a lifetime benefit for the kids where basically they could take a minimum amount out of that account, pay the tax on it as they take it. But the idea is if they're taking out a little bit at a time and they continue investing the money, what they're growing is growing tax free and they keep on getting more money out. Now, last year, 2019, the rules changed. So instead of being a lifetime for the kids, it became a 10-year window for the kids. Some people might think, well, that means what's the point of doing all this if it's only 10 years? In one sense, it's actually more important that the kids are careful with what they do because they have to do this within 10 years. And because this comes out quicker than over their lifetime, it's not the easy, well, I'll just take the minimum distribution each year and forget about it for my lifetime. That's kind of the easy way to do it. That's what it was in the past. Today, they've got 10 years, and the change in the rules also is that it's not a consistent amount every year. They could take a consistent amount every year if they want to for 10 years. They could divide it up over 10 years. They could take a little bit more one year and a little bit less the next year. But they only pay the taxes on the amount they withdraw each year. And they could even keep it all there for 10 years. One thing to think about, for the kids, especially when you think about how old they might be when they end up inheriting, let's say your kids are in their 60s when they inherit these IRAs. They might still be working. They're probably maybe at the peak of their career, making higher income, they don't, two things, they don't need the money right away. And if they cashed it out while they're earning a high income, they will end up paying tax on that at a pretty high rate. So one benefit now, actually under the new law, is they could let it sit there and not touch it for 10 years. And in 10 years, they've retired. They could, have a lower income. They could have chosen to delay taking Social Security. Effectively, you could see the kids retiring, having no other income besides this IRA that they can cash out after, that 10th year. And when you think about what the savings and taxes for them could be then versus if they cash it out right away. So the issue with an inherited IRA is trying to make sure that the kids don't kill the goose. Basically, you don't want to end up having your retirement account lose the benefit for the kids. It's a tasty goose, but it's not going to be as much as something that could produce yearly for them for 10 years. Any questions so far?
Yes, I do have a question. One of the questions is, what if I am leaving my IRAs to grandchildren or non-family members?
Okay, so the 10th year actually kind of starts the year after the person died. So by September 30th of the year following the date of death. And so it's actually the 10 years starts then. So it's actually a little over 10 years is what you actually end up getting. So that's when it starts. And I see another question. What is the tax rate when the money comes out of the IRA? That's a good question. It's not like a traditional investment where you might be thinking capital gains, which is a low tax rate. It's taxed at the kid's personal income tax. And the other thing to think about that's not obvious with this is the way income tax brackets work. Let's say your kids are a married couple, they're earning, they each have jobs, they're each earning $90,000 or so. They have, good paying jobs. They could be, together, they could be up in the 24% tax bracket. Tax brackets could change in 20 years. They might be at the 35% or 37% tax bracket. So the taxes they pay, on their own personal income is going to range. You get taxed on the first chunk, and then you get taxed on the amount from one level to the next. So not everything you earn as an employee is taxed at your highest tax rate. But think about the retirement money that they get from you. That comes on top of what they're earning. So if the kid's highest tax bracket is 37%, everything they take from your retirement account will be taxed at 37%. So that's where I talk about here, the mistake kids make is they could, under the current tax brackets, they could lose 37% of what you leave them if they cash it all out while they're working. So that's the difference about taxing. It's not like capital gains. It's not like their own personal income because it's going to be on top of their income. This question about Roth IRAs. So no, so that's actually one of the things we'll talk about later on is a Roth IRA, you've already paid the tax on the money that you put into the Roth IRA, and there's no tax on the earnings from that. So you would think it's a nice, easy thing to leave to kids without having to worry. I'll sort of talk about how the Roth IRA can play in with the tax advantage legacy trust to spread the tax burden around, because most people don't have just a Roth. Most people have a mix of 401k or IRA, traditional 401ks and IRAs, and Roth 401ks and IRAs. So, and actually, yeah, Jim has a question here that covers that. So if you've got imagine you have a kid in a low tax bracket, they're not a high earner, and one of your kids is, a high earner, they're, they're a bank manager, and the other kids are, an art student. I've actually had clients with that actual situation where, they have a son who is an artist and they have another son who, went to work for Fifth Third. And, both of them obviously have different tax bills, and they'd like to treat the kids the same. But if you just simply said, well, I'm going to give half of all my retirement to each kid, the child who's working with a high income will end up paying more income tax on their share. So with the trust, one thing you can do is you can actually say some more money from the Roth will go to one kid, more money from the traditional IRA will go to the other. So the high earning kid can be given money out of the Roth versus the low earning kid can take money out of the traditional IRA. That can reduce the tax for both. They'll both still end up, and you can also make sure that they both kind of get a fair amount. Because basically, otherwise, the high earner is going to really get less than the low earner. And the Roth does still have that 10-year withdrawal limit. And that's another thing, actually, I didn't really talk a lot about in the outline here, but it's another benefit of the trust is when you have situations where kids have incapacity, or if one of them is in a nursing home, the rule is the tax has to be paid within 10 years. It doesn't mean that the money actually has to go all to the kids in 10 years. So, if you want the lowest tax rate for everybody, you pay out the money to the kids in 10 years. If you have a child who has a health problem, has a mental health problem, a physical health problem, a disability, you don't need to give them all that money right away. So the trust can actually hold on to the money. It gets taxed differently. There's rules about that. But when you pay it out to the kids, the trust can reduce its tax costs that way. So that's a little more complicated, but that's one of the things that the trust makes easier because the kids aren't the ones who have to figure all this out. The idea is that there's also a trusted person you've put in place who can administer this for all the kids. The question about converting to a Roth. So no, the kids can't convert their inherited IRA to a Roth. Now, obviously they can take their inheritance and put it into their own Roth, but they can't really convert the one you leave them. So, getting to this topic about the mistake that 98% of kids make. So the interesting thing about the inherited IRAs is that few kids actually take advantage of it. Right? And the statistics are about 90% of kids take that check on day one. They have, they do the withholding on the full amount. And since it's, free money to them in a sense, they don't think about the fact of how much they're losing. So really what they end up doing is, you leave them $100,000 inheritance, they end up keeping $60,000, $67,000 of it because they've had all that money lost to taxes. And the difference is that they can leave the money there and the money continues to grow. That full 100,000 grows. It's not like, because once they paid the taxes, they're not getting growth on that money they paid to the taxes. So if they pay taxes earlier than they need to, they're just losing out on more investment growth in the future. And the other thing about retirement accounts is that the average kid will have about $60,000 saved in retirement. It ranges in, amounts from 30 to 80,000 depending on their age, but that's not a big retirement. So your IRA that you're leaving to the kids can make a big difference to them. So the concern is you want to make sure that they're secure. This can really be kind of the jump start to their retirement savings if they haven't been saving enough. And if they end up paying taxes on that instead of letting it sit there and grow, they're losing that ability to have that money get invested. So that's kind of what the mistake kids make. And so you think about, why these rules are put in place. And it's really about, it's about taxes and collecting taxes from the kids. And so, what they're really, what the government has done is they've put in place a plan to try to make it more likely that your kids are going to cash it all out and pay taxes on day one. And the other thing is, if the kids can't let the money sit there for their lifetime, if they take it all out in year one, that makes the even easier for the money to be accessible to credit card companies, to debt collectors, and that's kind of one of the next, the danger for the kids is, what this can do to the kids unexpectedly, that they might not expect. So this has to do with something people don't realize, that your retirement account for you is a pretty secure investment. The government has rules that say if you get sued, if you have a bankruptcy, your retirement account is not going to be taken from you. Your kids, on the other hand, when you inherit an IRA, or your kids inherit your IRA, it's not protected. So lawsuits, credit card debt, student loans, bankruptcy, and divorce. And the thing to remember about how that works is, let's say your kids have inherited, $100,000, again, is a nice easy number. So they inherit $100,000. If they cash it out, let's say they have to pay $30,000 in taxes. But if they're in the middle of a lawsuit and there's a $100,000 garnishment against them because their business they started failed and they had a personal guarantee on the building that they, or the equipment that they used to start a business, or, their home is underwater and the housing market collapsed, that never happens, but, when it does, it happens. So those kinds of things that, never happen can happen to your kids. And that $100,000 IRA is suddenly a target for a collector. And, as an attorney, I've actually done this for clients where, in the past when I was doing, I used to do divorce law, and I do garnishments to collect on marriage or divorce judgments. And we had a case just like this where the ex-husband didn't pay what he was supposed to in the settlement. And we knew where he had his money. He had some money that used to be in an IRA that had a large tax bill owed if he cashed it out. So we garnished it, and guess who paid the tax bill, though, on cashing out that account? It wasn't my client. It was him who had the money. So in this example, my client got $100,000 tax-free because that's what the judgment said. He got hit with the tax bill, even though his money was all gone. The account was empty. I mean, that's what can happen to your kids too, is that money that your kids receive can all be garnished. And your kids are still gonna have to come up with the $30,000, $20,000 in taxes to the IRS. And the other thing about IRS tax bills, you can't get out of those. They can't go bankrupt. They can't get those wiped out. They can set up a payment plan with the IRS forever. They can try to get it reduced, but that's not going to just go away. It's like student loan debt. They're going to have that forever. So I kind of open up for any more questions here about this. If anybody has any questions specifically about, I don't know if you will, but if you have thought about this, or if you realized any examples where you had kids where they, or known anybody who's had their inherited IRA taken, that'd be a good one if somebody has something like that to mention. But that's the danger for the kids is leaving your kids back in there. My keyboard is acting up here. Okay, so that's kind of the danger is, income tax debt is going to be around forever. So, you could end up actually leaving your kids a debt rather than leaving them an inheritance. I mean, that's a worst case scenario, but that's something that could actually happen. And so yeah, so I'm looking at a quick couple of questions here. So yeah, there's a danger obviously for the kids that they could end up being collected against. But in terms of how you leave money to the kids, there are ways to leave money to the kids that shields them from creditors, from garnishments, from divorce. So that's the thing to realize is the big thing is you put the kid's name on an account as a beneficiary, they're not liable, now your money's not at risk now for their liabilities, and it's not their money. But after you die, if their name's on an account as a beneficiary, that suddenly becomes their money that's accessible to their creditors. If instead the kids are a beneficiary of a trust, and assuming the trust is written correctly, the trust will shield your kids from creditor claims. Trying to get some. All right. So that's kind of what a trust, and the trust is a shield for your kids. It's going to stop the kids from having that taken. There's a question about, how to protect an IRA that you already have inherited. There's really, you're not allowed under IRS rules to take an inherited IRA and just put it into a trust. You're really at that point you're going to have to, if you're worried about that kind of concern, you'd have to cash it out to put it into protected trust. So that is one thing. If you've already got an IRA that you inherited, that's a situation where you might have to take it out to protect it if you're concerned about that, especially if you have, one example where I say, people most often end up losing money is, your kids aren't gamblers, most kids aren't drug addicts, most kids aren't bad kids. But a lot of people that I meet, a lot of our clients have kids who are entrepreneurs. They start a business. They decide to open a restaurant, and they never expect a pandemic to shut down the restaurant for a year. That kind of things, those kind of things happen to kids. They're going to be trying to start, and that's really the biggest factor where I see people lose a lot of money is, to get a business loan, banks often require personal guarantees. And I've seen people who've lost houses and lost, investments to a failed business through no fault of their own. It's just, businesses do fail. Investments are a risk. And startup businesses are a risk. So what is a tax advantage legacy trust? So there's kind of two things I think of when I think of what the tax advantage legacy trust is. The name we give to trusts that are specifically written for retirement plans. And it's different from just any other trust you might be leaving your kids' money in. Two specific things that this trust does that a lot of trusts don't. The first one is it's a shield. So we already talked about the dangers to the kids. So it shields your kids, it shields the inherited money you're leaving from lawsuits, creditors, divorce, and bankruptcy. But the other part of it is that it's providing some guidance and control. So the big one is protecting the kids from themselves, making sure they don't cash it out at a bad time. A lot of kids probably don't even think about the consequences when they're cashing those out on year one. They just see, I'm going to end up with $60,000. I'm not, they're not thinking about where the other 30,000 went that they could have had, or thinking about the future growth that 30,000 could have meant in the future. So one thing that the tax advantage legacy trust provides is that there's an additional person that you put in place, or a bank or an advisor that you put in place that has to get involved if the kids want to take more than the minimum out. So if they want, if you want to make sure that the kids get the best benefit, you'll have the trust set up so that someone is named, that they can't just go in and take everything out they want. Um, Obviously, it doesn't always make the kids happy, but it's a way of ensuring that there's a benefit to them. And the other thing is, if you just leave it to the kids to take out their share, they might not be thinking about the fact of how to how to get more for everybody if they work together. And that's one thing that I'll talk about later on in the slide. Is I think I've touched on a little bit already. Is with the Roth and the non-Roth accounts, is that they can get more benefit. So the difference between the protection trust we do and the TALT is that kind of oversight that the TALT has. So the protection trust just says if the kids are over 40, typically, they can just cash it out. They can take everything out. And it's a division that's sort of done in advance. So every kid's going to have, if there's 4 kids, there'll be 4 buckets, and everything gets put into a bucket for each kid. With the tax advantage legacy trust, the trust is the beneficiary of the retirement accounts it can be a beneficiary of multiple retirement accounts. And that oversight, that person who's doing the oversight can pick and choose money from different accounts for each kid. And the goal is still, get everybody the share that they're entitled to, but they can also do it in a way that reduces the tax cost for everybody, increases the amount of money for everybody. So that's the difference that's one of the differences between the TALT and other protection trusts that we do. So that's where I talk about growing the inheritance too, is that, not just leaving the money in there as long as possible, but also, finding ways to reduce the tax bill for the kids, which increases the amount for everybody. Other things that I don't really touch on a lot about in the slide has to do with if you happen to have kids who are disabled or chronically ill at the time of your death, the TALT allows for the law allows for a lifetime stretch. And so the trust also allows disabled and chronically ill children to have a lifetime stretch of their share rather than the 10-year payout. It also, if it turns out, let's say you're leaving money to grandkids and they're a minor, if they're under 18, that money can sit there longer than 10 years. So it's 10 years after they turn 18 is the rule for minors. So those are things that the TALT can do, because there's language in the TALT based on the laws for retirement plans. A little different from the protection trust. The protection trust does protect retirement accounts, so it protects it. The protection trust is the shield part. It doesn't have a lot of the guidance and the ability to get more benefit out of the retirement plan. So that's the difference really between the two. So next thing I'm going to talk about is how the TALT can reduce the tax bill for your kids. That's kind of something that everybody wants to be able to do is the point of retirement plans is deferring taxes. And when you pay taxes, you want to reduce it as much as possible. And no one's going to pay more taxes than they need to. So obviously the first thing about reducing the kids' tax bill is making sure that they don't take that 37% hit in year one, and spreading it out over 10 years, a bit at a time. When you think about the difference in tax brackets, so if the kids, if you're in retirement that you're leaving to the kids, is in the order of hundreds of thousands of dollars, that's likely to bump the kids up into the top tax bracket. If they take a tenth of that every year, it's, that's going to reduce the amount they have, or the fact that since they can defer taking anything out for up to 10 years, if they're within 10 years of retiring, the smartest thing to do would be, if they don't need the money, take the money out after they've retired, when they don't have any other income. That's going to be a huge benefit for them. So that's something, and that's where I talk about withdrawing more in years of low income. Another example is, you've got kids who I like to use the business startup idea. That's something that it's just, the way the economy is for a lot of kids today is if they can, there's a lot more kids starting, a lot more people starting their own businesses. We've got a gig, what they call the gig economy. It's all about people out there starting businesses, not counting on the lifetime employment. So one thing about starting your own business, and I can tell you this from personal experiences, you can spend the first few years with basically no income. You can have a business that you're putting money into, and the kids end up actually having no taxable income. And everybody's probably talked to somebody who has their own business, or if you've had your own business, about the experience of having it work out where you're really not paying much income tax at all. If you've got the right, if you've got a lot of businesses with losses, the kids might end up actually having a zero tax bill. I mean, that's a great time for them at that time to take money out of their inherited IRA and then put it off when the business is doing better, or if they start having more income. So that's the other thing about the trust. And the the last bullet point here is what I kind of talked about before, is the difference between your kids, the high earning kids, the low earning kids. Actually, the question too about special needs kids. So the big thing about certifying that one of the kids meets the requirement for being chronically ill or disabled, it's basically similar to the rules for Social Security disability. Basically, if they've got a doctor's note saying that they're chronically ill or disabled, it's not quite the same as actually it's not as difficult as it would be if they're trying to collect disability from the Social Security, because they're not applying for something, but as long as they meet the requirements for being chronically ill and disabled, which generally is a doctor's diagnosis that they are chronically ill and disabled. So if you've got a kid now who would meet that requirement, making sure that they've actually been diagnosed, by a doctor, that you're not just simply, you don't want to have the situation where they're actually chronically ill, but no one ever actually gets them officially diagnosed by a doctor. So that's really what it comes down to. But for a situation like that, you might, if you have got one kid who isn't able to work and your other children are working, it makes a lot of sense if that one kid who's the one who's not working, the special needs one, their share of the IRA, or their share of the retirement inheritance could come out of your traditional IRAs, because then the tax gets applied to them at their low income. And then any Roths you might have can get applied to the kids with the higher income. And the math, it's a math problem at that point to figure out how to divide it up so that after tax money, everybody gets a fair share. That's doable. So that's not an impossibility, but that's where having that trusted advisor also makes a difference. Any more questions about reducing the kids' tax bills? So the next, that's kind of the last section of the slides, is how the will grow your kids' inheritance and actually increase the amount they have. We touched on these a little bit, but the biggest one is making sure that there, as much of your IRA that you leave them continues to grow. If they lose 37% in year one, I mean, there's sort of two, the two extremes are they could wait 10 years and pay 37% in year 10, or they could pay 37% in year one. But the difference is by year 10, the money's doubled. So they're paying 30, they're still paying a lot of tax, and the amount of tax they're paying is more, but that 37% also got to grow for 10 years. So that's the difference, is you can't grow the money that you've given to the IRS. The kids can't grow it. So, 10 years, people talk about investments doubling in 10 years, but it could grow more, so paying tax 10 years early is really losing the opportunity for the kids to see that investment grow in something else. Some complicated things you can do with these is if you've, one example would be if you left the kids money in a self-directed IRA they've inherited. You can have business property. I've seen, we've got clients who have rental property in an IRA. And so that rental property could keep growing in value, and 10 years can make a huge difference in terms of the value of real estate. The market in one place can go up quite a bit in 10 years. So that's where, money that if they've taken it out 10 years earlier than they needed to, that's 10 years of lost opportunity. The other thing is you set up these IRAs, you've got financial advisors, you've got investments, those can continue. That's a possibility. If they don't cash them out, those kinds of investment plans can continue. One example is that self-directed IRA, businesses in retirement plans. You've made some choices, those things can continue for your kids. We talk about a trusted person that you choose. One point I'll kind of make here is, our standard tax advantage legacy trust, we work with West Michigan Community Bank as that trusted advisor. They have a wealth management division. They have a trustee division. So they would be the ones typically named. They're the default that we name. But you can, if you've got a relationship with a wealth management firm that is able to act as a trustee in Michigan, or a bank that's willing to act as a trustee in Michigan for you, they can be named as that, what's called, the term in the trust is distribution trustee. So they're the ones in charge of deciding when to give kids more than the required minimum distributions. And they're also the ones who can decide that the kids aren't competent to receive money, so let's make sure that it's held for them, that sort of thing. So that's something, you can choose that person, but we also have someone that will name for you if you don't have someone. And the other one is making sure that debt collectors and tax bills don't take the money first. If the money's gone, it can't grow for your kids.
Bill, I have a question. Yeah. So several of the attendees are life plan family members. They have a protection trust, which is the Root Cellar Trust. Mm-hmm. And when did Carrier Law start doing the tax advantage legacy trust? And if I have a protection trust, why should I be looking at the TALT?
Okay, yeah. So the first question is, when we started doing the tax advantage legacy trust, that we previously were calling those retirement plan trusts. So if you have a retirement plan trust, and I believe we've been doing them since at least 2016. I don't know if they were being done before then, but the retirement plan trust is the same as the tax advantage legacy trust today.
Okay.
But there is because of the law change in 2019. The rule that happened in 2019 is that anyone who dies after December 31st of 2019, their kids, their heirs have to, have 10 years to pay the tax on the retirement plans that are inherited. The retirement plan trust we did in the past didn't require a payout in certain time frame. But they also don't say that they have to. There's no automatic in place of how to divide it up. It just says, um, basically by year 10, the tax has to be paid and the trust would still work. So the trusts we had in the past still work under the current law. The big thing is there's going to have to be some work, guidance from the distribution trustee, and that's the other thing is some of the trusts we did in the past might not have named West Michigan Community Bank. They might have named other banks. So the kids will have to work with that distribution trustee to make sure that, by year 10, money's taken out. But one thing really to consider is it used to be a simple, we always just figured, well, let the kids take the minimums over their lifetime. Don't do anything else. So the difference now really is, you sort of you can think about different options based on your kids. The standard one we still do is the same we always did, where there's no requirement that any additional money be taken out for the kids. And they still have to work with that distribution trustee, but there's nothing also that would stop the kids from ignoring it for 10 years, even though that might be a bad idea. So one thing to consider with the retirement plan trust is really it's more about what to do with your retirements than it is about the trust itself, because you really need to consider about the fact that if you're going to, if they have to take the taxes in 10 years, should you be leaving everything in a traditional IRA versus a Roth IRA? It becomes more about thinking about, well, if you've got a kid, with special needs, maybe you're going to leave them more of the retirement money because it's going to be a less tax burden for them. And in coordination with your protection trust, your house, your other things you're leaving to your kids, changing the plan really is maybe more of the thing to consider. There's nothing that's broken about the old trust. There's nothing that has to change. But the idea is that because the law puts this 10 years in place, that should really get you thinking about, what that means for your kids. And so that's one of the things I really strongly recommend is just having a review of what your plan currently is. What's going to, what the current plan you have in place is, even if you have a retirement plan trust, is there something that should change because of the 10-year rule now for the kids? So yeah, if you have a retirement plan trust now, there's no requirement that you change it to adults. The name is not going to matter, but it might be that the plan that you have in the trust you might want to change, or if you did the trust where one option we always give people is we can say, well, we don't want the kids' hands to be tied. We want to give the kids the option of taking it all out in year one, no matter what anybody else might say. And that's probably something you should consider changing because the tax consequences are bigger now. In terms of that, so the other question, so I see a couple of questions. So one thing about any retirement plan trust that we do is, the old ones and the current one, it's really a benefit for the kids because your retirement money, and that's one thing I didn't even mention, is your retirement plan stays in your name because you're already getting protections from lawsuits, creditors for your retirement money. Also, because the IRS doesn't allow us to take your retirement money and put it in a trust now while you're alive unless we pay all the tax on it. So, one thing though that's actually worth considering is, if you're considering doing a Roth conversion, but you're hitting limits on how much you can convert because there's rules about how much you can convert of your retirement money to a Roth each year. One option is instead of converting that to a Roth IRA, is converting it to an investment account in a protection trust. And if you've got, so just think, one thing to think about is if you have an investment that's non-Roth investment, that you put the money in and it sits there and it just stays there until you die, you're not paying income tax on it. If there's no income generated from that investment, you're not paying income tax on it while you're alive. So just like a Roth, you're not paying income tax on it, even though it grows tax-free. the nice thing about an investment like that is when the kids get it, if they sell it, they can actually take advantage of tax rules that actually can reduce their tax costs there. So that's probably a whole separate topic, maybe together with a financial advisor is, if you're looking at Roth conversions, also, consider different types of investments because, and the reason why I talk about putting that in the protection trust is you still want the protection for your savings from lawsuits and creditors. So you can basically get a lot of the benefits of a Roth using the protection trust without having to hit the limits for Roth conversions. Another thing, I like about that is you're getting away from the government's oversight of retirement accounts. It's your investment account, you have a lot more flexibility on that, a lot fewer rules that can put in place for that. Question about distribution trustee fees. So West Michigan Community Bank is, for example, that we work with, they generally have a fee schedule that ranges, and I think it's about 0.5% up to 1.5% per year. Most financial advisors that I work with charge about the same. So they charge about 1% per year to manage your investment. And part of the idea is that it's an active management. So the goal is that they're advising, they're recommending investments, they're making sure the money grows more than the 1%. The way it's a sliding scale with West Michigan Community Bank. So the more money you have, the lower the fee percentage. That's kind of the typical fees there. So your inherited IRA funds, so the rules for that are a little bit different. It depends. So if let's say you currently have an inherited IRA, it depends on when the person who left that IRA to you, when did they die, what type of IRA it is, whether it's an annuity or a traditional IRA. You can leave that money, you can name a trust as a beneficiary for that inherited IRA. Whether though it gets more than 10 year stretch for your beneficiaries is going to depend on specific details. So that's something more really, that would be something to meet with an attorney and talk about and figure out what the current asset is. Another thing I sort of wanted to point out too is, so one question I was going to sort of ask Chris to bring up, I forgot to, was that, or I should have mentioned it, is what types of retirement accounts can go in here. So we talked about Roth, traditional IRAs, certain types of annuities. One question I've often received from clients in meetings is, can my pension go to the kids? So that's a maybe question. Usually, most pensions can go to your spouse, and after you and your spouse have died, the pensions end. That's kind of the traditional rule for pensions. Some pensions might end when you die. Some pensions might continue for your spouse. There are pension plans out there that have been converted to an annuity. The company that you got the pension from might have gone through a restructuring or a bankruptcy, and instead of leaving you an actual pension, it's actually an annuity that pays you just like the pension, except the rules with the annuity might be that there's a cash amount that might be left after you and your spouse have died. So that's again another one where it depends on your specific pension plan and what you're getting. But that's with the TALT, the retirement plan trust. The one thing I can say is the only people really who have no need for one are people who have no retirement savings at all. So if you don't have an IRA or a Roth or an annuity, that's the situation where the protection trust is going to work for you. But because the retirement plans like IRAs and Roths have special rules, and also they have restrictions too. A couple other things I didn't talk about is that there's still a rule in place for retirement plans where If a charity is the beneficiary of a retirement plan, then or if a non-person is the beneficiary of a retirement plan, instead of 10 years, it could be reduced to 5 years. And that could also then, apply to your kids. So that's one other reason why we talk about doing a tax advantage legacy trust in addition to the protection trust is protection trust is a place, it's a general, you're leaving money to your kids, leaving money to grandkids, leaving money to, your favorite charity, leaving money to your friends, leaving money to anybody. Um, you don't want to have your retirement money accidentally um, get a tax hit because there's a charity that could somehow be the beneficiary of that money through your protection trust. So by isolating just retirement money to the tax advantage legacy trust, you're avoiding any current changes. And the other thing is future changes in tax laws could apply. This law that took place in 2019 automatically applied to every retirement plan that everybody had up to that point. So the same thing could happen with your current retirement. You might not have, there might not be a law that would affect your retirement plan if it goes through the protection trust today, but in the future it could. So if you have your retirement money separated from your other money, there's less chance of retirement money getting hit with some tax bill that you didn't foresee, that we just couldn't foresee. So we have some more questions. So if your child who is the beneficiary, if they die before they get to the 10-year payout, or if they leave money in the trust before they die, that's just like your other trusts. You can decide how you want to do that. Typically, most people will say they want the kids can leave it to their descendants, and they can leave it to their kids in trust. So it can go to their descendants if they want to. That's something you can put in the will to allow them to do that. Or if they haven't done anything at all, usually the way it works is, the trust is written to say the kids can leave it to whoever they want with some restrictions, because that's the other thing about retirement plan money is if, we have to put some restrictions to say that they can't leave it to, if they leave it to a charity, we don't want to have that affect your other kids' inheritance, because the tax rules for retirements are, if there's any, potentially, if there's any way that a charity or some non-person can end up being an heir of retirement money, that can affect everybody. So that's where the retirement plan trust, they can go to descendants, it can go to other people, but it also has additional rules in place to avoid charities and things like that. So another question is, if you have a current trust, a living trust with our office, you can definitely make an appointment to discuss that. There's no charge, no cost trust review meetings to talk about how to protect your current assets, or if you've inherited retirement accounts as well. Even if you already have an inherited IRA, like I said, you can't put that money into a retirement plan trust, but there's still things we can talk about what we can do to protect it for you now, how to make sure it's protected for your beneficiaries as well. So that's the big thing I would say is there's information, getting knowledge about this is important. And one thing I also like to make sure people are aware of is that retirement money is, the whole IRA thing, 401ks, IRAs, it's all a creature of government planning. So, every election cycle, every 4 years, there's likely to be a change to what could happen with retirement plans. The biggest thing about our retirement plan trust is flexibility and isolation. You really have to treat retirement money differently if you want to avoid the unknowns. And that's really what the big thing is with retirement money is there's a lot of unknowns. The only thing we do know is that, there's a lot of bills that are going to have to be paid. And the government conveniently has a lever that it can control on retirement money. It can control how your kids deal with retirement money in the future. So it's important that you're aware of that and that you have the flexibility for your kids to treat that money differently than just the regular inheritance money. So that's why I really recommend, especially if you've got a large chunk of your savings are going to be in retirement money to your kids. Um, meet with meet with an attorney at our office to talk about that. I would also, talk to your financial advisor. I think there's a lot of things we can do together, with using the protection trust, using retirement plan trust, using planning with your financial advisor. But today, of how you can get your savings to the kids in the best way possible. And I'm going to turn this back over to Chris. I think I need to do that here. Let me see. So I'm going to stop sharing. And so, Chris, do I have to make you the host now?
No, you're all set.
Okay. All right.
Yeah.
Any other questions? Anything else that anybody wants to talk about? I think
There's
I-
one
you know,
other,
what I should've
there's
done is
one,
put my-
yeah, there's one other question, but I also want to let people know, as you continue to answer questions, I'm gonna launch a quick poll because feedback is so important to us, and know that what we presented to you today, you found a good use of your time. And if anyone has any suggestions for other educational series webinars, if they want to put that in the Q&A as well, and we can tailor some additional webinars around that. So I'm going to launch the poll now. And Bill, you can continue to answer some questions. There's one about
Okay. Yeah.
when is the money moved? Yeah.
Yeah. So the question was, when is the Roth and IRA, or my IRAs or your IRAs, moved to West Michigan Community Bank now? And the answer is no. They don't. You can. You can move it if you want to, but there's no requirement that you change how you're doing your investment, your retirement now. You can keep on doing your retirement exactly the way you want to do it. You don't have to change anything. On your death, when it goes to the trust, then if West Michigan Community Bank's involved, they may recommend a move. One thing that I do want to point out that's is a concern is that for your kids, that some retirement plan companies out there just don't like dealing with trusts, and so it can happen where after your death, the kids will have to move the money because the company that they're working with doesn't want to deal with trusts. It doesn't mean, though, that they lose any of the benefits or that they lose any of the ability to invest it or that they lose the ability to invest it the same way. It just really, it's a question of, are they going to have a Prudential bank statement versus a Edward Jones bank statement or versus a Schwab. I mean, it's really, that's all it comes down to, is the administrator on the IRA account doesn't have to change, but the administrator might want to change it. That's just something we don't. Well, so the question about that September 30th of the year following a person's death. So that's an IRS rule right now, so it's September 30th of the following year. So if you died in September 29th, it's not that next coming, so it'd be the following year. That's the current rule that the IRS has. That what it means is by that date, you have to contact the retirement plan administrator, or the trustee will have to contact them, let them know what the plan is, how the money should be going. So that's what the rule is. It's an IRS rule that just says the IRA administrator has to be notified by that date. Otherwise, potentially they might just say, we're going to cash it out for you and withhold all the tax for you. So that's where, hopefully after you die, your kids are working with somebody who can guide them through that, because there are deadlines, and that's one of the deadlines that we don't control. It's just an IRS rule, and that's just it really is kind of a set in stone kind of rule right now. But it's the following year, not that same year. Any other questions? I'll stay on the line for a bit until Chris lets me know that But nice to see. I see everybody still, a lot of people still on, so feel free to ask any more questions if you have any. Checking through the chat here too to see if there's anything.
Yeah, I'd just like to thank everyone so much for coming today and sharing your time with us to learn about the Tax Advantage Legacy Trust. And if anyone is interested in reviewing their trust documents that you've created with us and talking about more about the TALT, feel free to give us a call, and we'd be happy to set that up. If you'd like to meet with Bill or one of the other attorneys, that would be great. And just to really appreciate you taking the time today and answering the poll as well.
Yeah. Just saw a couple of questions.
Yep.
So you can still get, you can move your money now to West Michigan Community Bank if you wanted to have them be the IRA administrator, and you can still get keep on getting your required distributions while doing that. So it's no different from if you changed from Schwab to Edward Jones, really. In terms of cost, like we always say, meet with an attorney in our office. They'll give you a personalized, quote and cost and benefit analysis. And, it's one thing to remember, it's always a free meeting. But really kind of what, I wouldn't always consider the TALT as just like, it's not like you're going to come in and just say, I'm going to do this a standalone, because it really should be done in consideration with everything else you have going on with your plan. Because there's usually nothing's as simple as I'm going to do one thing. A well-done estate plan really has to consider the whole big picture. So that's kind of what I would say. But it looks like there's no other questions right now, but I'll just sort of keep on hanging out while people are still online. I see. It looks like Chris has shared the poll results. I don't know if that's with everybody or is it just with me, but glad everybody seemed to like the presentation though. Feel free to ask me more questions.
I think that's it, Bill. I do want to let everyone know that this has been recorded and it will be up on the website probably within the next, probably by the end of the week. And if anybody is interested in what is a trust review, that was our last educational series. That recording is already on the website. Again, that's under the workshops tab and educational series, and right at the bottom. And we have 2 coming up. They'll be posted soon, and that's going to be about probate and trust administration. So again, I thank you all so much for your time today. And thank you, Bill.
Thanks.